Hello, everyone. Good afternoon, and welcome to Memorial's Technology Transfer and Commercialization Office Workshop Series. My name is Paula Mendonça, and I'm Memorial's Director of Innovation and Entrepreneurship, and I also lead the TTCO. The TTCO, our Technology Transfer and Commercialization Office, is here to be a streamlined point of contact for the university to help move innovation forward, from intellectual property education, like today, to research commercialization. We are also here to make collaborations between Memorial and industry move forward smoothly. If there are specific questions about Memorial's IP policy and how our office can help, please contact us. The session today will be more a general discussion about intellectual property with our guest, Noel Courage. Before we start, however, I would like to recognize that we acknowledge that the lands on which Memorial University's campuses are situated are in the traditional territories of diverse indigenous groups, and we acknowledge with respect the diverse histories and cultures of the Beothuk, Mi'kmaq, Innu, and Inuit of this province. Today, I would like to welcome Noel Courage, a Newfoundlander and Labradorian that happens to be a partner with Bearskin & Parr, a leading Canadian intellectual property law firm. Noel is a lawyer and a US and Canadian patent agent and was recognized in the 2021 Best Lawyers in Canada. Today, Noel will be talking to us about intellectual property and commercialization with a focus on science and medicine research and discoveries. With no further ado, Noel, the floor is yours.
Thank you, Paula. I'm happy to be here and I appreciate the invitation. I know we have people from Newfoundland and from Ontario on the line, maybe a few other provinces, so it's great to get you all together virtually for this discussion. I'm just going to share my screen. Please feel to jump in if you have questions. You can put them in the chat and we will get to them all. And one moment. Okay, here we go. So today we're going to focus on IP and protecting IP in a publication world, because you still do need to publish, and how to move forward with your academic research and to be able to protect IP and publish. It's more of a coordination than anything else. There's streams that you follow, and we tie them together quite neatly. So quick overview, we're going to talk about types of IP, patentability, the interface of patents and value, quick bit about commercialization agreements and freedom to operate, and then we will turn the floor over for questions. I'll be speaking for about 40 minutes, and then we'll have lots of time for questions and answers. So first off, IP, the best way to think of it is not as something you go out and start suing people. IP does provide monopoly rights, whether it's patents, trademarks. We'll get to these in a bit more detail. It does provide you the exclusive right to use that creation you've made, but really the best way to think of it is an asset, not something to sue people with, but an asset like a car, a house, in that you can buy IP, sell it, you can license it to others and give them permission to use it. So that's the way I like to look at it, because of course you don't want to be suing people, you want to be collaborating with people. That's our mindset, particularly in the academic world. And IP is important because by having those rights, investors, and even more these days, grant funders are deciding what to fund based on IP assets. So we're not saying in this talk that you should or shouldn't file an IP, but just that you're aware of the basics and think of IP, and then it's a cost-benefit decision for you whether to pursue it. And you can feel free to call the Tech Transfer Office or myself to kick around any of the ideas that come up today. So a quick overview of the main types of IP. Trademarks are your brand, basically. Copyrights prevent reproduction. That's something that's quite familiar to most people. Industrial designs protect appearance, trade secrets, and patents. So you could be dealing with all of these or some of these on any given project. Trademark is basically a brand or a logo. It could be a word, it could be a word and design combination. And these days, it can sometimes even be a shape or a color. And just as a quick tip, if you're designing a brand for a business or a service, as soon as you start using that to differentiate your wares, you can mark that with a TM. You often see that, but you can mark it at the first occurrence as a TM to indicate to the world, the first occurrence in a business plan or on your website, that you consider it to be a trademark. if you do go ahead and register, which is a good step to do later, then you can file for it with, you indicate with an R in a circle. But for now, even if you take no steps to register it, you can mark it with a TM. Copyright prevents reproduction without authorization. So we're familiar with that from books, music. It's a common topic in the university world. But I want to emphasize that copyright also applies to software code and engineering drawings. So the practical applications of your research. If you're doing something in medicine that has an app, there's software code involved, and you need to be thinking about copyright and who owns that. If you're the one developing the product, you want to tie up these loose ends to ensure that you're going to own the software code that's produced on your behalf. So that's owning the code, owning copyright. So be aware of that issue. And again, check in with the Tech Transfer Office for specific questions about your situation. Copyright is good at preventing someone from cutting and pasting your code or your engineering drawings or your manual if you're designing a chemical assay for something like that, for how to run the manual. It does provide protection from copying, but it doesn't protect the concept. So someone can independently make their own version and you don't have protection. Basically protects copying. It doesn't protect function and it doesn't protect mere facts or information. So a good example that was in a court case in Canada years ago involved maps from the Canadian Hydrographic Service. The data was found to not be anything more than facts and information, so it wasn't copyrightable. But the maps and the product of applying that and the implementation of that idea in a particular expression could be protected by copyright. So keep that in mind if you're dealing with data. Data now can have some rights attached to it. If you keep it as a secret, it could be a trade secret, but again, it's a fact-based situation. So you need to just kind of be aware to think of these things, that if you are compiling a lot of data, how are you going to protect it? Are you not looking to protect it at all? Are you looking to publish it? So just be aware that there is IP in these areas and that there are potential IP rights that you may have. To mark something with a copyright, so if you have a website or if you have a business plan or other proprietary information, you can see in the bottom left here, copyright 2021 Memorial University of Newfoundland, which is now Newfoundland and Labrador is the full name, but you indicate it in that manner. You can mark it with a copyright. Just again to indicate to the world that you consider it proprietary. So you don't need to register to be able to market this way. It's a good practice to start doing that now. If you have, again, if you have instructions for how to run certain chemical processes, etc., and you consider it proprietary, mark it confidential and copyright. Industrial designs are typically directed to an article's appearance. So this tends to come up a bit less in science, but I still wanted to briefly flag it. Trademarks and copyright, as I was saying, you can have some rights without registering. With designs, you don't have any protection for the appearance of an article unless you file a design application. And basically, I think this is important. In medicine, there's so much more interaction between medicine and technology that, for example, you see big companies and small companies developing apps often. If there's a pharmaceutical product, well, there's often a website or an app that goes with it these days. So things like icons on your graphical user interface, where you put a slider button, the shape of the icons on the screen in the middle can be something you could protect. If you're in ocean sciences and using sensors, or if you're in the computer science division, physics, if you're using sensors and you come up with a neat design for a sensor housing that is attractive and you want to protect it, then that's the sort of thing you can file an industrial design on, called a design patent in the US. So trade secrets, so everything in university can potentially start out as a trade secret, and you do have some basic protection there. Um, you can keep the secret until you publish it. Quite often, we're building towards a publication in the university environment. If you file a patent application or other IP, it will be published. If you disclose the secret at a trade show, an academic conference, etc., you've disclosed and put it out there. Again, it's a balance because quite often you have to. A peer-reviewed journal will often require you to deposit some information. in the paper or in a database as a requirement of publication, so the data can be reviewed. So again, it's something where trade secrets may not often be compatible, but sometimes it can be. Things like computer code or algorithms can potentially be a trade secret. If you think of Google, you never see what their algorithms are. You type the information into a box, it gets uploaded to a server, and then you get a result back. So trade secrets may have a place in some of what you're doing. It's just good to be aware of that type of IP. To have, as I mentioned, things like other things, just a quick diversion, manufacturing know-how, if you're at that stage, could be a trade secret, algorithms, chemical formulas, and synthesis. That's the sort of thing that could be kept as a trade secret. Business plans, so not just technical information, but also business information, customer lists, can be trade secrets as well. To be a trade secret, you have to treat it as a trade secret, which means you have to take steps to protect the information, which means you need to password protect it. You need to, if appropriate, have a physical barrier to prevent everyone from accessing a sensor device. If you are using that as part of your research, use non-disclosure agreements, bind employees and contractors to obligations of confidentiality, limit the number of people who know about it, and keep people on a need-to-know basis. So these sorts of things show that you are treating it as a trade secret. Again, there's pros and cons to this type of thing, keeping a trade secret, because it is uh, anything secret, of course, as we know from high school and our undergraduate days, anything that you try to keep secret is vulnerable to public disclosure by accident uh, or the other means. People can reverse engineer. The departing employees have risks as well. We'll quickly talk about that. People who make an independent discovery of the same trade secret are free to use it. And there is a risk if you keep a trade secret and somebody else patents it, they may be able to get a patent because the use that you made was secret. So other people can still get a patent on something that's of interest to you. Just as an example of how basic trade secrets can be and how you have to be aware of the environment in which you're operating, mayonnaise of all things had a well-known case that went to court. Basically, a departed employee from the Hellman's Mayonnaise Company went to somebody who was doing private label mayonnaise, soupy, not very good mayonnaise, and it was found that trade secrets were disclosed. So mayonnaise is not hard to make in a basic way, but if you scale that up to a commercial scale, it is quite difficult to do and have it come out nice and fluffy and taste good. So even basic things. So for example, if you have a particular formulation that you use for culturing cells that is unique to get good cell growth, that may be a trade secret. If you have particular ways of synthesizing compounds or growing cells, that could be a trade secret. Now again, you have to decide whether it's the sort of thing you really want to lock down and keep as a trade secret or publish it, but just to be aware that you may have rights. Uh, just to, again, to make the point too, that the way the trade secret was leaked is that a departing employee did take it with them to the new company. Um, the company that owned the recipe did go to court, did get an injunction preventing the private label manufacturer from using the trade secret. So they are rights and they're enforceable. Another quick one, Clamato, summer drink popular in Canada, was another one. I mean, it's basically a tomato concentrate clam broth. So again, even basic chemical compositions can have a trade secret aspect to it. The Clamato company did not invent that beverage. They just had their own version of it. Uh, it their trade secret dispute came up when they broke up with a distributor, basically, and the distributor did their own version. I won't get into the details of it, but basically the distributor went with their own version, went back on the market, and was found that the distributor had used the knowledge of the prior formulation to create its own, and then they springboarded ahead onto the market in a way that they would not have been able to do from scratch. So think about what you are generating as proprietary, if that is the way you want to go. Again, if you want to publish it, great. If that's more benefit to you, but if you want to keep a trade secret, then you do have to treat it like a trade secret. And point being that the bar for establishing a trade secret is not that high. It is property. You can license that trade secret to other people and commercialize it. And you can keep it as a trade secret until you ultimately decide to publish it down the road or file a patent application, which will later be published. So that's your basic IP. So we have 3 types of IP we've covered where you have some protection without spending a cent. Trademarks, copyright, and trade secrets. So back to the point about coordinating publication, which is what we want to really emphasize here, that IP and publication can coexist. And when should you check in with the technology office at Memorial? You can give them a call. You can call Paula, Kara, anybody in there at the point where you are preparing a grant. If you just want to say, you know what, this is what I'm thinking of doing. Here's what may come of our research and what IP could come of that. Is there any IP now? Do I have some IP in my background work? When should I think about protecting this IP more formally by filing, for example, a patent application? So check in early. It's much better to check in early than to check late, because if you've published your IP, if you put it out there, you may have eliminated your ability to file a patent application for that IP, because some countries say once you publish it, the IP rights are gone. In the US and Canada, there's a 1-year grace period to file, but places like Europe, if you publish, then that can eliminate your patent rights straight away. Again, if you've done sort of a low-level publication, you've not put it all out there, you put some of it out there, the situation gets a bit gray, but I would say you can always pick up the phone and call the Memorial Tech Transfer Office and speak to them about it. Advantages of protecting the IP, where would we go? So discuss what IP could exist, what is the potential scope of IP and value, so they can help with that assessment. They can explain to you how to do some landscape searching to see what's out there, to see what is the potential value and scope of the IP, talk about ways of brainstorming, because they do have a good awareness of funding. So could protecting the IP draw in additional R&D funds or other commercial money? If you have an idea about approaching a company, they might have a plan they can formulate with you about how to do that and when to do that. Even to use the correct terminology in IP for IP in a grant proposal. People often describe patentable inventions as a trademark. As we talked about earlier, trademark is your logo. If you build a better mousetrap, if you're coming up with a new use for a known drug, if you've got a new diagnostic assay, then you're looking at patenting or trade secrets. So just getting the wording right, even though it's a brief paragraph, to make sure you've got that can improve the competitiveness of your application. And once you've reached the end post of developing some IP, I mean, it's a long road. We're probably talking about an initial end post, and then there's always more after that on the way to the market. But how to make a plan to protect the IP? Is patenting worth it on a cost-effective basis? How should I coordinate patenting or other IP protection with publication? The typical case, we just can file a patent application if it's a good strategy, and then you publish. So it's not saying don't publish, it's just saying just do it in this particular sequence. So other resources, we have MCE and CSE on campus. Bounce is not part of the university, but they are on campus and they do have some resources. So you do have lots of people to reach out to in addition to the tech transfer office. Do a quick deeper dive on patents. We're not going to get into procedure, but it is a very procedural area, time consuming, expensive. So the benefits of patenting really have to be established on a cost benefit basis. Patents, basically, we talked about IP providing monopoly, exclusive rights to an invention. Patents can protect chemistry, structure, function. They must not be publicly disclosed before filing a patent application. As I mentioned, there are grace periods in Canada and the US, but you don't really want to rely on that. You want to make the decision whether to file a patent or not before you publicly disclose the invention. and then just, again, arrange things accordingly. Patents are country by country, so if there's a patent in Europe, it has no bearing in Canada. You'd have to file a separate patent in Canada, so it's country by country. And how long does the protection last? Well, typically 20 years from your patent application filing date is the term. It can be a bit variable, but that's typical benchmark. To be patentable, the invention has to be new, useful, and inventive, has to be patentable subject matter. So if you're in the computer software area, if you're in the computer sciences faculty, you may hear that software is not patentable. It really depends. In some cases, it can be difficult to patent in Canada and the US, but in other cases, you can patent the methods, the processes around the software, particularly if there are technical aspects that meet the criteria for patentability. If you have sensors, if you have an output where you have controls, things like that, the more physical features that are integrated, the more likely it is patentable subject matter as long as it's new and inventive and useful. So if you're in the Faculty of Computer Sciences or Ocean Sciences or any of the faculties, if you're crossing over into the computer area, I would say just put a bookmark that what you're working on may well be patentable and it's worth talking to the Technology Transfer Office and seeing what IP you may have. Again, it's not all about patents. It may be something that you can keep as a trade secret uh, on your server, and so people don't see it. And just have a bookmark to go in and talk to people about at the Tech Transfer Office about what may be patentable. And again, it's not always about patents because designs, trade secrets, trademarks, copyright may have a role as well. Remember, copyright is applicable to computer code. A couple of quick examples of IP. This one is from Atlantic, Canada. Shrews are venomous, not to give anyone nightmares or anything, but shrews are actually, from a taxonomy point of view, they're not related to mice. They are a separate stream. People in biology are saying, yeah, tell me something else that I don't know. So I'll try to tell you something you don't know. But for me, it was traumatic to find out that shrews are venomous. So a company called Soricimed, based in New Brunswick, isolated the peptide from shrew venom that was responsible for that activity. Shrews basically will go out and get an insect and paralyze it, bring it home, keep it in their little den, and then I've got snacks for later. So it's the stuff that good horror movies are made of. There's a paralytic peptide that they named Soricidim, blocks ion channels, including one called TRPV6. And not only is it paralytic, but it does have analgesic pain-killing properties. So that's great. They found a peptide, they've sequenced it, um, and they have US and European patents on medical uses, applications of the peptide, and then they filed internationally. So they came with something, they filed it. But what I want to emphasize is that it's an iterative process because initially they knew of the analgesic use and property of this peptide, but they also shortened it. So let's take this peptide, it's 40 something amino acids, let's shorten it and see what happens because you want to find out what is the active part of the peptide. But they didn't just find out what was the active portion of the peptide, they found out that it did have some anti-cancer activity. So that was an improvement to their original invention, and you can file a new patent on that. And they found out that there were diagnostic uses as well because this peptide bound strongly to the TRPV6 receptor. It wasn't just taken in and degraded, it binds. And so then if you put a fluorescent label on that, cancer cells produce, some certain types of cancer cells produce a lot of extra TRPV6. So then if you put a fluorescent label on your peptide, put it into somebody, it will gravitate and light up that cancer cell. So interesting diagnostic use. And you can see an example of the fluorescent marker attached to the peptide detecting an ovarian tumor. So IP is something to keep in mind as you go along. So if you're developing, just an example, somebody finds a peptide or a compound that's got some initial activity. Maybe you didn't discover that compound. Maybe it's not a new compound. Maybe it's a repurposed compound. Still worth having discussion with the Tech Transfer and Commercialization Office. Can we protect this new use? Or if it is a new compound, can we protect this new compound? Even if you haven't characterized it very well biologically, still consider whether the compound itself and some basic characterization data may be enough to file a patent. When you're writing up the grant about going down this pathway to investigate these new compounds, that's an even better time to check in and see what may be patentable, or to at least have a plan for what might be patentable. Seeing what is out there, getting a sense of whether your compounds are novel or whether some of your compounds are novel and some are known, well, maybe you then direct your research a bit more towards the ones that are new compared to what's out there already, because you can get a stronger IP position. Again, all things being equal, because it does have to be of academic and publishable value also. So it's just putting more factors into the decision pot to help guide your research. And as you get farther down the pathway, you will find that there are more opportunities to collaborate. So initially, maybe collaborating with people to help characterize compounds, develop compounds, synthesize compounds. Maybe they're providing you with compounds, so you're collaborating from the get-go. But as your research goes farther, you're only going to find more collaboration opportunities, things like contract research organizations, research institutes, hospitals, partnering with big companies. All this has come up. All these collaborations came up in the example of the peptide that I was discussing. So what you need to do again is think, what is the IP situation here? What IP do I have? What IP am I bringing to this collaboration? What are my collaborators bringing? If they're testing a compound for me, are they bringing a cell-based assay for me to test? Are they going to do the hands-on testing? Do I want to tell them about the compounds and get them involved in interpreting with the results, or do I want to give them the compounds on a blinded basis and just have them run their assay and all do the interpretation? So there are many things to think about in a collaboration beyond just the expertise and capability of the people you're working with. You want to think about how you're collaborating with people from an IP point of view, and you want to think about having IP agreements in place before the collaboration begins, because once the research is done, there's really no incentive for partners to sign agreements later. They may sign it, they may not, but the best time to do to get IP agreements in place, ideally saying that you, your company, your institution own the IP, if that's what the arrangement is, get that in place early on. A quick word about freedom to operate. So having a patent doesn't give you the right to use an invention. If you file a patent application, that means you're believing you've got something new and inventive. You're going to negotiate with the patent office, hopefully get a patent out of it. But having a patent doesn't necessarily give you the right to use an underlying invention. So if there's a class of compounds out there that are known and you've modified that class of compounds, find out you get much stronger anti-diabetic activity, let's say, you may be able to get a patent on that compound if it's not known, but there'd be a bigger question as to whether somebody has got a patent on the class of compounds and you'd need to get a license from them. So the patent grant doesn't give you rights to use the underlying invention. It gives you rights to protect your own product. If the company with the underlying patent wanted to use your compound, then you would give them a license to your IP rights. If you wanted to commercialize your compound yourself, you may need a license from them to use their patented rights. So there is that kind of interplay. Likewise, if you're working in ocean sciences and you're using a sonar system, you've developed a really good improved application for that, well, there'd be a question as to what types of sonar systems are patented, and do you need a license to use some of these systems? So bear that in mind. Computer science in particular, there's lots of patents out there that competitors may have. You kind of want to have a sense of what's out there already, see if you can get a license. If you can't get a license, maybe you can design around the patent, work outside the margins of the patent so you stay clear of it, or maybe you can take a comfortable position that the patent is really not valid, so you're not at that much risk if you were to do something within the patent. So the way we assess this is by doing freedom to operate searches. If you know competitor names, leading researchers in a certain area, it's relatively straightforward to do searches for patents by name. It's more complicated to do searches for other people's work by subject matter. but it's the sort of thing, it's a bit easier if you kind of chip away at it on an ongoing basis as opposed to waiting until you're into a due diligence process with an investor or a funding agency. And they say, what's the freedom to operate position? And then you have a big frantic attempt to figure out the freedom to operate position. So got to keep these two issues separate. Can I patent what I'm working on? What IP rights do I have? Do I have trade secret rights? What are my IP rights versus what are other people's IP rights? And how do I navigate with respect to those? So two very important concepts, easy to mix up, and you've got to be able to explain them and how your technology relates to those when you're speaking to funders. So commercializing IP. So this is really kind of a recap as to what the best practice is. So when you are writing a grant application or when you've got some research banked, you want to determine what the full extent is of your invention or the invention you're planning to make, and what variants could you make? How broad could that IP position be? Assess the scope of potential patents. Make and regularly revisit the cost-benefit assessment. Is it worth paying for a patent and proceeding? Can you keep coming back to this cost-benefit analysis as you go along before additional funding is spent? Is your money better allocated somewhere else? Should you pull the plug on patenting? This is something very important for universities to do because there's limited budget available. So you and the university kind of need to cooperatively decide, is it worth jumping in? And then is it still worth it at the 1 year point? A couple of years later, is it still worth paying for patenting costs? How broadly can we protect that? Is it time where the inventor, if the university can pursue the commercialization, uh, is the inventor going to take back the rights and proceed with it or just drop it? So the cost benefit decision is very important because it's not just an expensive process, but it also becomes a time consuming process for researchers to be involved in because you do have to negotiate with the patent office, you do have to argue about patentability and the like. Determining inventors and securing ownership is very important as well. So inventorship and authorship, if you have questions about with that, we'll come back to that. But inventorship is different than authorship. We do need to know who the inventors are, and it's not the same as who may have given you materials could be an author who may have suggested some research, who may have done some background work that really is not the crux of the invention. You have to be an inventor. The validity of the patent is at risk if you don't get inventorship assessed properly. Securing ownership also is important. If you are going to be going into a project, who's going to own the IP? If you delegate all the coding, if you have a project in mind, and you give it to a contract IT company, or you get a contract student to do coding, if they do the coding, even though it's your idea, they may have rights, they may own the copyright in that code because they're independent contractors. So if you're going to own the code and the product of their work, then you want to have an assignment of IP and you want to have confidentiality over what it is that they are working on. So important points to consider. Firstly, to own the IP. Secondly, you don't want to prejudice your patent rights if you don't have control over the IP. Where appropriate and where justified by cost, you file applications to register IP, and you need to be able to address freedom to operate and have an action plan for that. So one more quick example, just to show IP in action. So this is a glucose meter. If you have blood sugar issues, use this to measure what your blood sugar is. If your blood sugar is high, you may take insulin. If your blood sugar is low, you may take some juice. So this helps you know what your blood sugar is like. So it's an interesting combination of computers, medicine, the device at its crux does require chemistry as well. So it's an interesting example that covers all the basis of IP rights. So the brand name, Bayer is the company that makes it. Their trademark is Contour, and so they apply to register that for their specific medical diagnostic device. Copyright, there's all kinds of copyright around it. There's software that goes with the product. You can plug in the glucose meter, it will download your data. So the website, the manual, the computer code all has copyright on it. Computer icons as well, I mentioned, can be protected by industrial design potentially. They may have some copyright depending on how they're used also in the artistic aspect of it. Industrial design, so the nice shape of the device that we saw back here. Basically, you can file an industrial design and protect the appearance of that. It's not that complicated. I mean, you wouldn't say that that's any striking intellectual property, but the layout of the buttons in relation to the screen, it does have some narrow protections. So you can't protect with this registration, basically a screen and buttons, but you can protect your very specific design from close knockoffs. Patents, of course, are very important in this area. It's a biosensor, and basically they have a conductive layer deposited on a support and reduces background reactions and gets rid of signal noise. So the chemistry of this device is patented, and that's part of the overall protection. Again, the chemistry's got to be new and inventive, but if you're depositing chemicals and getting a better result, making coatings, reducing signal noise, all these sorts of things are cues that there's a commercial application and potential IP. Trade secrets, of course, to make a device at scale, you need to make them fast and cheaply. So manufacturing the glucose meters and test scripts, there's a lot of know-how, trade secret knowledge, how to do that, temperatures, conditions, chemistry, tons of trade secrets around that. It's not worth patenting on the cost-benefit analysis. The source code, if there's computer code that's used only in-house or whatever is on the software that users, if you're storing it in your cloud, they never see it. So you do have some trade secrets there as well. Again, risks of trade secrets are people reverse engineer it and it doesn't protect the concept, and it has to be something where you can keep the secret because there's risks of eager employees accidentally disclosing at conferences or trade shows, and departing employees, if they know the information, there's a risk with them too. So you have to be able to keep the secret. So proactive IP management. Here, you've got a confidential design, testing, you file a patent application for an invention and its variants, you publish and disclose after you file a patent application, then you're looking for partners for commercialization. And as you go along and you make improvements, you consider, well, should I protect this as a new patent? So again, initially confidential, file a patent application, coordinate that with your publications, whether in a journal article, conference, even a research day is a potential publication risk. So if you're not sure if what you're doing is a publication, talk to the TTCO and ask about it, because you can't take back the publication once it's out there. Thesis, of course, is another one. Thesis can be often be embargoed to prevent a publication, but just communicate with the people who have IP experience and they will guide you in the right direction, okay? Reactive IP management, just to reiterate this point, is you publish it, tell the world, and then you afterwards think about protecting your IP. As well, sometimes people file very narrow IP. You want to protect your invention and its variants. So key concept in IP that you'll hear is how broad is the IP? If it's narrow, other people can design around it quite easily. So you do want to have broadly worded IP. And that starts with filing a broad patent application or trademark application upfront that protects your innovation and its variants. IP agreements, we're not going to say too much about this, but we do want you to be aware of the different types. Assignment agreement, if somebody asks you to do an assignment, they're talking about an assignment of ownership, so transferring ownership. So not just look for an agreement-headed assignment agreement, but if somebody gives you a non-disclosure agreement, if somebody gives you a research collaboration agreement, where are the assignment of IP agreement clauses in there? There's usually a couple clauses that may transfer your ownership away. Or if you're outsourcing some work to a contractor, you want to have an assignment of IP agreement so that you own the IP, whether you personally or if the university is owning the IP, they own the IP, or your company. Confidentiality is a key provision to have. What restrictions are being put on you if you're being asked to sign one? What restrictions of confidentiality are you putting on other people if you're the one asking for the confidentiality? How long will it last, etc.? Collaborative research agreements, so important contracts, they set out requirements for people to complete research, who's going to pay. So good to get this done. If you're in a commercial environment, it's not always appropriate to do informal collaborations. I know that a lot of universities is done very efficiently that way, but if there's IP, commercial prospects, then you probably want to formalize that in an agreement. Be sure that people have clear expectations because the collaborative research agreement sets the expectations for timelines and etc. Material transfer agreement, particularly if you're in the biotech area, if you have genetic sequences that you're transferring out, protein samples, chemical samples, etc. If you're giving someone computer code, you basically want to have control about what's being transferred. You want to have restrictions on people copying it. DNA is easily replicated. You want to have specific restrictions on copying, and that's the material transfer agreement. The role of the material transfer agreement is to restrict what can be done with that material and to ensure it's returned to you or destroyed after the collaboration. And a license agreement is basically permission to use. So are you giving people permission to use a license? Technology of yours. So you'd be giving permission to the license. What is the scope of the license? What field is it applicable to? And what other agreements come up? Well, distribution, supply, manufacturing, etc. These are all important agreements. So just be aware that they all are strings and you need to know what you're getting into. Collaboration agreements are necessary. Again, just to reiterate the point, to have these in place before the collaboration begins. They manage expectations, define ownership, and they restrict use. So this is basically a synopsis of the points of the goal of the agreements. Protect IP, control IP, manage expectations, define ownership, set out commercialization expectations, restricting use of your information. Okay, so these are the goals that it's not free and loose by and large when you're generating IP, but an ounce of prevention is worth a pound of cure in this area. So just to close back on a point we began with, IP is an asset. So think of that way. You're generating property. Buy it, sell it, license it. Investments and funding are made based on IP assets. So it's really critical to have a plan. Not to say that you necessarily want to protect IP. You may want to go completely open. That's entirely appropriate in some cases. In other cases, the way to get the technology out there is to attract investment for development and to get funding and protect the IP because that will get commercial partners to get it off the bench top and deployed. But it's a case-by-case thing. And so there's a lot of good resources at your disposal at the university to help talk to these issues. And you may decide it's worth protecting your IP, worth patenting, etc. Or you may decide to go to the conventional publication route. But the key thing is to be in the position to make an informed decision proactively and not end up in a reactive situation. And just to close out the glucose meter example, so the IP that was built around that was sold off. So when you're selling it, you are selling not just a manufacturing plant for glucose meters, you're not just transferring a business and a customer list, but it's the patents, it's the brands, all that information is what creates the value. So if you have the IP, you are in a better position and at a better valuation than if you don't. So again, proactivity is key, making informed decisions about whether you're going to protect IP, how to protect it, and just reach out early on and we can help you make these decisions. So that concludes the presentation. So we can open the floor to questions now. I'll turn it over to Paula to mediate those.
Thank you so much, Noel. This was very helpful. As usual, I always find that I learned something new, even though I've seen your presentation. Well, I like how you always change your examples and they're always very pertinent to what we're talking about. So I really appreciate that.
My pleasure.
We do have a question, so I'm going to jump right in. And I would say it's probably more for me than you know, actually. If academic research is funded by an outside partner, but an outside corporation, can the corporation insist on having all or part ownership of the IP? And the answer for that is yes, everything is negotiated, and I'm talking about memorial as well. So there's always IP agreements, intellectual property agreements are going to be negotiated between the industry collaborators and memorial, and those terms, including IP ownership, is discussed at that point. And actually, that brings me to one question, Noel, that kind of falls into that. That is sometimes the difference between authorship, ownership, and inventorship of intellectual property. And I don't know if you want to touch a little bit on it.
Yes, so authorship is the most magnanimous. People who contribute to a project are likely to be named as authors. When it comes to inventorship, at the patent office, you have to name the inventors correctly. It's who's made a intellectual contribution to the concept of the invention. So the invention may involve all kinds of assays. Somebody may be having difficulty synthesizing a known compound. For example, if you're repurposing a compound, there could be a lot of work done to get that compound. If the invention is really the new medical use, for example, well then the inventors wouldn't be the people who figured out the synthesis of the compound, because the compound is a known compound. They did a lot of work, a lot of sweat equity. They'd certainly be authors on a publication, but you'd look to, okay, well, who came up with the idea that this compound would actually be useful in diabetes? Because it was not known for that before. It was only known for heart disease, and it didn't work well in heart disease, but now the diabetes data looks great. Like, whose idea was it to test it in that system, and who did the tests and interpreted the results? So those people who did that work would be the inventors. And then as you characterize the uh, peptide more and more, you might work with a contract research organization or another lab, just kind of figure out the bounds of the applicability using known assays as to how it affects glucose activity and glucose levels. Well, those people who are doing that assay work are probably not inventors either, if it's routine work and any lab technician could do it, but they may be named on a publication. So inventorship really hones in on who came up with that specific concept. So it's a very good question, Paula, and a very important point. It's got to be discussed with the research group proactively and diplomatically. Ownership is the third thing to keep in mind, is that regardless of who made the invention, anybody could end up owning that if there are agreements in place saying that for example, an outside company is going to own it. So if the research was funded by an outside organization, everyone agreed that, the university agrees, the inventors agree, everyone's on board that it's going to be owned by the company, well then, the company's not an inventor. The scientists who are the inventors, they would be transferring their rights to the company through a written assignment of ownership agreement. And then that company can transfer its rights to another company, transfer ownership. So the owner can change again. It can transfer bundles of rights. It could transfer the Japanese rights to a Japanese company. So it's licensing those rights out. So there's a lot of concepts as to who can own. In the base case, if I go home and make an invention this evening, if I come up with a better mousetrap, I'm the inventor and I own that. But that is changed in a lot of situations due to agreements between the researchers.
Thank you, Noel. That's helpful. And there's another question. How can you find out if your invention is unique and innovative? Are there databases that can be searched? Are comparisons relatively clear-cut, or is there often a judgment involved as to whether a previous invention exists?
So this is the sort of thing that Paula and I deal with on a regular basis, and it's whether or not an invention is patentable and how to assess that. So it's kind of within our bailiwick, and we're happy to share that knowledge to anyone who calls. We are happy to talk all day about patentability and whether an invention is patentable and what area does it fit into. But basically, there are ways to assess patentability, and any researcher who walks in to our office, nobody's walking into our office these days. I don't know what I'm talking about. I must think it's 2019. We're still laying low here in Ontario. But any researcher who contacts us on WebEx or Zoom, they have half the picture in place as to what the background is and what the literature is. And we help fill in by reviewing the patent literature, or in some cases, we explain to the researcher how to look at patent literature themselves. There's really good online databases have been coming out the past several years. Google's patent database is getting better. It's a free database. You just type in patents in the Google search engine. You may not want to type in the crux of your invention, use generic search terms, but that has a good global reach so you can see what other people have done. But quite often people say, you know what, Noel, your team, or Paul, your team is used to searching patent databases. If you have some searching that can be done, that would help us. We will then give you the search results back, talk about what is different, what's similar about the work, and try to find what is unique. So if a compound is known, well, we talk about whether your medical indication is known. If a chemical is known for a particular coating use, it's not known for a battery type use, well, we talk about how that would work. Environmental remediation, talk about the work that's out there and what you're doing that could be different and distinct. And so there is definitely a judgment call. And sometimes if it's not clear that it's going to get a patent, you kind of weigh that against the commercial value. If there's a challenge to get a patent, but the potential upside is big, you might take a shot at it. If it's a specialty item, it's not got a big market, it's going to be difficult and expensive to get a patent, then the cost benefit analysis is not just there. So amongst the prongs of the decision are firstly getting the patent searching done. So again, the more the researchers know, the farther ahead we are in our work to assess patentability and do searching. What is patentable? How broadly can it be patented? What extent do we expect the patent office to challenge it? Can we get a broad patent that covers scope? Or are we going to be stuck with a narrow patent that other people can design around, or maybe no patent at all? And does the cost justify patenting? So all these are the key judgment factors that go into the discussions that we have with the TTCO and with the researchers to figure out whether to go for a patent.
Thanks, Noel. And yes, it is true. We deal with this on a daily basis. One question that I actually might need some clarification, that is, in accounting terms, does goodwill include IP? And I'm not very clear if it means that if there's an agreement with another partner, if you're bringing IP into that agreement, if that counts as goodwill in terms of against agreements. I'm not clear. I don't know if, Noel, you have an idea of the question.
So I won't get into any accounting. I can barely keep my own finances in order, but I would say that goodwill does come into play sometimes in the US, for example, if you're transferring a trademark, because a trademark is something that differentiates your product and services from other people. If you're transferring the trademark, you see assignments that say we're transferring the trademark and the goodwill associated with it. So there's talk of goodwill. As far as technology like science and things like that, engineering type inventions, so talking patents, things like that. We don't talk a lot about goodwill. I mean, obviously you want to generate goodwill around your product, but we don't talk about it from an IP point of view. I don't know what the accountants do with it on the books. You'd have to ask one of them. I do know that for early stage inventions, this is not an accounting issue, but if you go to a bank, for example, for their purposes, they will attach a low value to the early stage technology because they often don't know what to do with it, as we say. They don't know if it's fit to eat. So you may not get a much value attached to it, whether you slide into goodwill or not. But any accountants here, feel free to type a note into the chat on this if you have anything to add.
Thank you. And I don't have any more questions on the chat or coming to us through the Q&A. I'll give a couple of minutes in case. I know we're almost at the top of the hour. But if anyone has other questions, please feel free to just put a comment.
Yeah, and feel free to follow up after. And I think it's important, anybody who has a question on the tip of their tongue, please type it in the chat box, because I know that there are some people from Ontario who are good people on the line, but they're going to start typing things about the Toronto Maple Leafs soon because it looks like they may win a playoff series. So don't give them the airwaves.
I have one quick question in case we have something coming up that I actually asked on the last session that we had, but we have a different roster of people attending. When is sometimes the best time to file a patent application? And the reason that I ask that question is that we come to a lot of the times people come to our office thinking that their research outcome is ready to be patentable. And sometimes it is, sometimes there's more R&D that needs to be done. And why is it important that sometimes we don't file a patent too early, but of course we also cannot leave it for too late. So that sweet spot.
Yes. Well, I would say there's another question too, which is when to contact your patent attorney or your tech transfer office about filing a patent. And I would say that's as early as you like. Call next week if you want, if you've got some ideas in your mind, and we'll help you sort it out. Now, the timeline to file a patent, I would say it is, as you're saying, you don't want to file too early, you don't want to file too late. But it is a system where the first person to file for an invention gets the invention. So we kind of put the scale towards filing early where we can. You can't file when it's speculative. So if you have made a bunch of chemical compounds and you don't know what they do, well, you maybe you need to specify some sort of usefulness for it to file on those compounds. Um, when we're talking about more clinical-based work, there's a question as to, what sort of data do we have? How much is it enough? Can you really generalize from the diabetes in vitro assay or from the cancer immortalized cell assay? Can you really generalize to clinical efficacy? Do we want to get a bit more research under our belt? So it really depends. But I would say if you're doing, I know what this is for the Faculty of Science, but if you're dealing with something that has mechanical aspects, as soon as you can draw it up, you don't need a prototype. As soon as you can draw it up on paper in enough detail that somebody could implement it, then that is ripe for patenting. And on the biochemical side, I mean, if you've got the compounds, if you got new compounds, definitely check in with Paula's office and ask about patentability and timing. If you're on the bio side, dealing with new compounds, new proteins, et cetera, definitely check in early. If you're repurposing compounds, proteins, et cetera, check in early because, again, it's a case-by-case decision as to how much is enough. But as well, I'll add one more point to this too, is that you definitely want to check in and consider patenting before you publish. So regardless how early or late stage you think it is, if you're about to publish, send an abstract to a conference that's going to be published online, go to a trade show, go to a research day, any of these things, put a thesis out there, do a defense, check in beforehand. And we'll help you make the decision whether to start protecting IP now or hold off. Or
Thank you,
maybe say,
Noel.
sorry, one last point. In some cases, we can actually adjust the content of the presentation so that you're just talking about results. You're not really giving away the secret sauce.
Yeah, that's right. And that's a lot of the times what we do if it's not at that sweet spot of the patenting yet. No, thank you so much for coming again and for taking on our invitation to be here. I also wanted to thank John for helping everything move smoothly, not slowly, smoothly on the tech side. Thank you everyone for attending. Any questions, do not hesitate to come to the TTCO or to come to Noel with any IP questions you might have. Thank you, everyone.
Thank you for attending, and thank you, Paula, for the opportunity.
Thank you.